In today's video, we're looking at the consequences of using a fee waiver to buy time for those people who are on the skilled migrant route and therefore have a CoS. And in certain circumstances, those people who are on the skilled migrant route may have their leave curtailed, cancelled. Usually, if the sponsor's license has been revoked or cancelled or withdrawn, it's very likely that those who are working for the sponsor and have leave to remain will receive a letter from the Home Office saying that their leave to remain has been cancelled or will be cancelled in 60 days. It also advises them that if they have any other grounds to remain in the UK, then they must make an application within that 60 days. What I've noticed, and a lot of lawyers have also noticed, is that unscrupulous advisors and some agents are then using the fee waiver application to delay the process because they usually will promise the migrant that I will get you another CoS. And therefore, because that the CoS I'm going to find for you will take me a month or 2 months to find it, I'm going to make a fee waiver application for you to delay the 60 days or to buy time for you. Time buying is not for fee waiver. If you want to buy time, don't use fee waiver. Fee waiver is for human rights application, family life application, private life application, in certain instances, asylum seekers who are applying to renew their residency or humanitarian protection. It is therefore important that if the intention is to go for another CoS or switch to another skilled worker route, you cannot use the fee waiver. Because when you complete the fee waiver forms, there's a declaration that you make. The declaration is to the effect that everything you've said on the forms is true, and that you are aware that any false information or documentation that you have provided on the fee waiver form can be used against you, including prosecution. It is therefore important that we take this thing seriously. When you're signing a form, there's always a declaration. The declaration on the fee waiver is to warn you that if the information you've provided above, and the information you've provided above is that the reason why you want the fee waiver is not to buy time, but is to make a future family life application, private life application, 20-year application, 7-year application, parent application, partner application, or asylum application. It is not to buy time. You've made this declaration that you could be prosecuted. You've also given information to the effect that you will be making the application that I've listed above, which is a family life or human rights application. But your intention is not to make the human rights application. Your intention is to go and find another CoS and switch to that. If that is your intention, then it means that you've misled the Home Office. And under our law, if you take the skilled migrant route appendix SW 2.1 says that if you provide false information, your application can be refused under Part 9 of the Immigration Rules. Part 9 of the Immigration Rules is refusal, sometimes discretionary refusal, other times mandatory refusal of applications. The most severe part of paragraph 9 or Part 9 of the Immigration Rules is the consequences in relation to refusal. So under 9.7.2 is a mandatory refusal. If you use deception and if you apply for fee waiver and you state that you're going to make a family life application, private life application, human rights application, and then sign the form and approve the declaration that you are aware that if you provide false information, you could be prosecuted. Subsequently, if it turned out that your application was only to buy time and hold the position, because under Section 3 of the 3C of the Immigration Act 1971, when you make a fee waiver application, it's deemed as an application and it holds your place so you don't become an overstayer if you make a fee waiver application in time. And therefore, if the intention is to hold your stay and buy time, it means you've misled the Home Office. You've used deception. And once you've used deception, it is a mandatory refusal and you'll be banned for 10 years. So these are the consequences. Consequences of lying to the Home Office using deception under the law could lead to a ban of 10 years, automatic refusal of your application. Future applications will be refused. The most severe is prosecution. Under the 1971 Act, specifically under Section 24 of the 1971 Act, if you do anything illegal, including being deceptive to the Home Office, you could be prosecuted, and the conviction could be up to a sentence of 2 years and a fine. Please, it is dire that we don't do these things. And the reason why I'm providing this advice is that I find it that people who should be knowledgeable, particularly agents and advisors, are also doing this. Fee waiver is for family life application. It's not for skilled worker application. It's not to buy time, and it's not to use it to look for a CoS. Therefore, don't do it. And if you're an advisor, you could be also prosecuted under Section 84 of the 2009 Immigration and Borders Act. It's very key that we all become alive to some of these problems. And that is why I'm sharing this video. So please, as I've said, fee waiver is for family application, human rights application, and not to look for CoS or use it to buy time. Be advised that if you do it because of the declaration on the fee waiver, you could be punished, you could be prosecuted, you could be banned, and your application will be refused. If you like this video, please share. However, if you want further advice, please call BWF Solicitors on the numbers above and follow us on TikTok, Facebook, YouTube.